Hello and welcome to the second video on the topic of holiday and furlough. If you haven't yet seen our first video on this topic, please go to the website and check that out. This video is part of the 9 St John Street Employment Insights series. These videos are covered by the disclaimer on screen now, and I'll pop that up again at the end of this video. As always, if you would like specific advice from a member of our team on this or any other employment law topic, please contact the clerks directly by telephone or by email.
I'm Rebecca Eeley, and I'm here again with my colleague Amy Smith. This video is the second of two dealing with the issues raised by the interrelationship of holidays and the new furlough scheme. In this video, we will be dealing with whether employers can force employees to take annual leave during furlough and the correct rate of pay during periods of annual leave during furlough.
The next question we're going to cover is, can an employer require an employee to take annual leave whilst on furlough leave? And if so, does this only apply to the statutory element?
Again, this raises the question whether the purpose of furlough and the purpose of annual leave are mutually exclusive, say in the way that maternity leave and sick leave have been held to be in previous EU lines of case law. For example, all the way back to Stringer at the ECJ, it was observed that there is a significant distinction between annual leave and sick leave. The purpose of paid annual leave is to enable the worker to rest and to enjoy a period of relaxation and leisure, whereas the purpose of sick leave is to enable the worker to recover from illness. If this view is taken in the context of the CJRS, and if it's considered that forcing an employee to take annual leave when they cannot, for example, go on holiday abroad because of current restrictions, is in effect preventing him from taking proper annual leave, then, the argument runs, you cannot force him to take annual leave during furlough because in effect you are depriving him of his full rights. This argument rather depends on the supposition that in order to constitute true annual leave, then the employee must not be fettered in any way in the way that he spends the time. Annual leave must in effect include a right to go on holiday. But if annual leave is just an extension of the concept of rest days, where there is no obligation to do work for the employer, but no particular expectation as to how you will spend the time, then there can be nothing wrong with forcing annual leave during furlough. It would be a distinction without a difference. This latter position, however, does not really take account of the significant restrictions currently imposed on all members of society. Not only are standard holidays abroad out of the question, so are many of the social interactions of normal day-to-day life. Employees on holiday during furlough are not supposed to leave the home save for limited exceptions at the current time. Perhaps this makes it more likely that forced annual leave during furlough will be seen as denying the employee's core right to meaningful annual leave.
So what guidance can we obtain on this? Well, the ACAS guidance has recently been updated and suggests that employers have the right to tell employees and workers when to take holiday, so long as they follow the notification requirements of the working time regulations. So, Regulation 15 of the working time regulations provides the employer with the right to insist employees take a certain period of holiday leave on particular dates. They do, however, need to give the required notice. It seems that the ACAS guidance is based on the normal application of the working time regulations. The guidance doesn't have statutory force though, but in the absence of government clarification, it might be all we have to go on. Therefore, if an EU-style approach is taken, then an employer cannot force annual leave during furlough. If a domestic regulations approach is taken, then he can.
This dispute cannot be resolved in the immediate future without government guidance. On that basis, whilst employers may be able to force furloughed employees to take annual leave, it is surely safer to do this by consent. If an employer cannot do it by consent, they may need to think about and explain why they want to do it without consent. Is the concern that they will have to let the worker take a lot of holiday in the period immediately after furlough, thereby making organising the workforce difficult? If so, they should remember that the entitlement can now be spread across 2 years, so that this difficulty may be more hypothetical than real. Also, as roll-on, roll-off furlough is now permitted, there is nothing to stop an employer ending a period of furlough, reinstating the contract, and then using the existing regulations to force annual leave at a time of its choosing. Sure, they will have to pay the full annual leave pay outside of furlough, but at present we do not know whether the government would seek to recoup furlough pay for designated holiday in any event, as we explained in the previous video. The purpose of the furlough scheme is to help tide employers over until the situation improves, and arguably not to subsidise employers' pre-existing obligation to pay holiday pay.
In addition, now that there is the carryover provision in the amendment regulations, an employee may seek to argue that, despite the employer's instruction, it is not reasonably practicable to exercise the right to annual leave during the furlough because of the lockdown. The employee may seek to force the carryover of the annual leave, see the new Regulation 1310. As we don't know which, if any, of these arguments may succeed if challenged, the safer way forward is to try and do these things by consent. Remember, only the 4-week period is derived from EU law. Perhaps in due course, the additional 1.6 weeks domestic statutory leave will be treated differently. Perhaps it will be possible to force leave during this period, but not during the first 4 weeks of annual leave. Or will the tribunals and courts attempt to achieve consistency of treatment for the total 5.6 weeks of annual statutory leave?
For anything over and above the statutory entitlement, the parties will have to refer back to the terms of the contract. If those terms already give the employer the right to dictate which days are taken as contractual annual leave, then presumably this contractual right will persist during furlough. If not, then we would have thought that there would need to be a consensual variation of the contract. On a side point, we appreciate that normal methods of communication with employees have been affected by the current crisis. We would recommend, therefore, contacting all employees on furlough and requesting their consent to be contacted by email. A database ought to then be kept and emails sent out with the appropriate notice length given.
The next question that we're going to cover is, at what rate should holiday be paid to employees under furlough, 100% or 80% of normal pay? Unfortunately, the answer is currently unclear. The updated government guidance for furlough pay, not relating to holiday pay, indicates that you can claim 80% of wages up to a maximum of £2,500. The employer can claim for any regular payments he is obliged to pay his employees. This includes wages, past overtime, fees, and compulsory commission payments. However, discretionary bonus, including tips and commission payments and non-cash payments, should be excluded.
So what about holiday pay in furlough? If applying EU principles, the general principle would seem to hold fast, even during these strange times, that employees must not be discouraged from taking holiday. Therefore, holiday pay ought not to be less than they would have received had they been at work in the normal way. So, whilst employers are not obliged to top up from 80% to 100% during normal furlough, would they be obliged to top it up to full holiday pay rates if it was designated as annual leave? Arguably, yes. Otherwise, the employee is being disincentivised from taking annual leave.
According to EU law, holiday pay must correspond to normal remuneration based on periods of actual work. Time constraints here preclude a detailed analysis of the rules on normal remuneration, and so viewers are referred back to the extensive case law on this point. Suffice it to say that holiday pay governed by EU law principles has a much wider scope than domestic law would suggest. It can include overtime, including compulsory non-guaranteed overtime, and in some cases, voluntary overtime, which is paid with sufficient regularity. It can also include commission related to the employee's work, bonuses, including some discretionary bonuses, especially if they are in some way intrinsically linked to the employee's personal performance.
This test of normal remuneration applies to the guaranteed basic 4-week statutory leave derived from the Working Time Directive. It does not apply to the additional statutory leave of 1.6 weeks provided for by Regulation 13A of the Working Time Regulations. For that additional leave, reference should be made to the relevant sections of the Employment Rights Act 1996 for guidance on calculation. Suffice it to say that the Employment Rights Act provisions give a narrower entitlement. For example, they only include overtime, which is both compulsory and guaranteed, and discretionary bonuses are more usually excluded from the calculation.
So where does this leave us in relation to payments for holidays taken during furlough? Our provisional view is that in order not to fall foul of the principles of EU law and disincentivise the taking of annual leave, the employer is probably required to top up the furlough pay to what would normally be paid in respect of holiday pay, at the very least in respect of the 4 weeks guaranteed by the Working Time Directive. This will include not only 100% of the elements of basic pay set out in the CJRS, but also 100% of the normal remuneration covered by EU law. For example, pay them what you would have paid them had they taken the first 4 weeks of their holiday in normal, non-furlough times.
And what of holiday in excess of 4 weeks taken during furlough? Arguably, if the holiday taken is part of the additional 1.6 weeks of domestic origin, then the EU principles do not have to apply. However, it is still being described as holiday rather than furlough time, so arguably you should pay normal holiday pay pursuant to the domestic regulations, as the Working Time Regulations have not been expressly disapplied. That said, there is an argument that you are actually reverting to the 80% furlough pay rather than 100% Working Time Regulations pay. Many of us could disagree about whether the employer has to pay anything more than the 80% pursuant to the CJRS after the basic, that is to say the basic Regulation 13, 4 weeks. However, there is clearly a risk for employers that only pay 80% basic pursuant to the CJRS, that they may be challenged by disgruntled employees and subsequently have to pay normal holiday pay in line with Regulation 13A of the Working Time Regulations. At the end of the day, what an employer chooses to do and what risks he is prepared to take will depend very much on the characteristics and priorities of the business in question. As with so much in this area of law, it is very fact and situation specific.
If our view is correct, then in terms of the practicalities, it would seem that the employee is entitled to 4 weeks holiday pay at the non-furlough rate. The government will pay the 80% as set out by the terms in the CJRS, and the employer will have to top up the rest to a normal EU level. After the 4 weeks, arguably the employer is released from using the normal EU remuneration rule. Then they can revert to paying holiday at the Regulation 13A domestic rate. If this is correct, this would therefore mean that for an employee on furlough with 80% pay, if they are on annual leave, they will need to be paid 100%, including, potentially, commission, overtime and bonuses. However, once the scheme is finalised by the government, the employer could only reclaim, at most, subject to our comments in the previous video, 80% pay without discretionary bonuses to be paid by the government. The employer would then pay the remainder.
We appreciate that it looks as though the employer is likely to be out of pocket. However, subject to the government reimbursing the 80% for holiday periods, in the long run, they are still paying less than they would have done had the leave been taken outside of furlough. But we do note that for those employers who have employees on large discretionary bonuses, this could still prove very costly.
We must emphasise that this is a preliminary view and government guidance is changing almost daily. We will endeavour to keep you up to date with these changes in forthcoming videos. Thank you for watching this video. We look forward to hearing from you with your questions. Please send them to employmentinsights@9sjs.com. The team will be posting a new video soon. We hope you stay safe and well. Goodbye.